Paul. She has representation on global solidarity and the rule of law.
Good afternoon, everyone. At first, I would like to share the screen. So, first of all, I would like to express my profound gratitude and heartfelt regards for giving me this platform to present my paper on the topic Global Solidarity and the Rule of Law, Rethinking Legal Mechanism for Sustainable Justice in a Divided World. So, the 21st century uh, faces a paradox. On the one hand, countries are more connected than ever through trade, technology, and travel. On the other hand, the world is also becoming more divided through politically, economically, and culturally. In this situation, peace and justice cannot survive unless we strengthen two key ideas. First one is global solidarity, and second one is rule of law. The that is global solidarity, the idea that the humanity shares responsibility beyond borders. And the principle behind the rule of law is that the power should be controlled by laws, not by the forces of politics. The rule of law, likewise, must be reimagined not merely as a domestic constitutionalism exported globally, but as a collective legal ethos capable of binding uh, diverse states and peoples into a shared normative framework. The concept of global solidarity has long existed within the normative architecture of different international frameworks. That is the Charter of United Nations and ideals of collective security and common responsibility, embedded solidarity in the maintenance of international peace and security. Similarly, principles such as self-determination, human rights, and the sustainable development are also grounded in solidarity, even when contested in application. Yet the absence of coherent mechanism to translate this normative commitment into a binding legal obligations continues to weaken the international legal system. Complicating this landscape further are systematic challenges ranging from rising nationalism and geopolitical rivalries to crisis and global pandemics that strains the legitimacy of existing mechanisms. Now, the paper argues the solidarity should not remain just as a moral slogan or soft law. It should become a binding legal principle in international law. When combined with rule of law, solidarity can help build a fairer or more sustainable world order. The theoretical foundation of my paper is uh, no country can solve um, issues like war, climate change, pandemics, or inequality alone. The UN Charter and the Universal Declaration of Human Rights already include solidarity-based ideas like peace, development, human dignity. Then the treaties like ICCPR and ICESCR turned some of the ideals into legal commitment. The idea that duties owed to all humanity also reflects solidarity in law. The rule of law, on the other hand, means predictability, accountability, and equality before the law. Internationally, it should mean that even powerful states are bound by norms. Together, solidarity means international laws are moral direction, while the rule of law makes solidarity enforceable. Now, talking about the present challenges, unfortunately, the world today faces many challenges that weaken solidarity and the rule of law. Let me highlight some of them. First one is rise of nationalism and populism. Many leaders now focus on their national interest, and many times refugees are neglected. Climate deals are ignored. Climate issues are ignored, and cooperation is seen as a threat. Next one is erosion of multilateralism. The World Trade Organization dispute system is paralyzed, and the UN Security Council often fails because of veto politics. Next one is fragmentation of dispute settlement. As we all know, there are courts like International Court of Justice, the International Criminal Courts, and many other regional courts, but they sometimes give conflicting judgments, and the state should avoid. Um, the states can avoid accountability by refusing jurisdictions. Next one is North-South divide and global inequality. The rich countries dominate lawmaking and resources, climate negotiations, and the uh, climate negotiations and the COVID-19 vaccines distribution showed deep injustice. Next one is selective compliance and double standard. The powerful states often ignore international ruling when it doesn't suit them. This weakens trust in law. In the case of um, Nicaragua versus United States, uh, the United States rejection of International Court of Justice exemplifies such defense. Now, talking about the sources of solidarity in international law, first one is UN Charter, United Nations Declaration of Human Rights, then Rights to Development Declaration, and many others. Uh, Now, talking about the existing legal mechanisms, there are already international institutions that try to uphold peace and justice. First one is the International Court of Justice. There are many important rulings on collective responsibility, but limited because states must consent to its jurisdiction. Next one is International Criminal Court that tries individuals for war crimes, genocide, but struggles with legitimacy, cooperation, and enforcement. Um, Next come United Nations Human Rights Systems, which is good for monitoring the various violations, but ultimately non-binding, and its decisions are non-binding and are often politicized. Next one is that there are the various regional courts like which which is strong in some regions but weak in others, leading to uneven justice. Now, talking about limitation of the existing legal mechanisms, um, there may be their voluntary um, compliance and selective participation. Next is structural inequalities, politicization of human rights institution, and fragmentation of global versus regional courts. Next, talking about rethinking legal pathways. The fragmented performance of the existing mechanisms and underscores the necessity of reimagining the normative and institutional architecture of international law to ensure that solidarity and the role of law are not merely inspirational values but binding principles. New pathways must be developed. These pathways should prioritize embedding solidarity into the sources of law, strengthening enforcement mechanism, and fostering inclusive participation that transcends geopolitical divides. Um, some of the issues I'd like to discuss that is re- reconceptualization of the solidarity as a binding legal principle. The solidarity has been relegated to as a status of soft law, articulated in general principles, resolutions, or various provisions of treaties. However, several developments suggest a trajectory towards its jurisdictional solidarity. The concept was affirmed by International Court of Justice in Barcelona Transactions, which recognizes duties owed to the international community as a whole. Next one is reforming the International Court of Justice. Uh, 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 the International Court of Justice remains central to the global dispute settlement, yet its consent-based jurisdiction limits effectiveness. Reform could include the establishment of compulsory jurisdiction in matters involving many obligations such as genocides, environmental protection, and crimes against humanity. Additionally, procedural innovations such as advisory opinions at the request of non-state actors like regional organization could democratize access and enhance solidarity-driven judiciary. Now, talking about revit- revitalization of the International Criminal Code. The International Criminal Code's legitimacy depends on universality and impartiality, expanding the membership and particularly among the powerful non-parties requires diplomatic innovation. One pathway could involve incentivizing accession by linking international criminal code membership to benefits such as trade privileges or development assistance, thereby embedding solidarity into broader governance regimes. Equality, equally important is enhancing um, enforcement, the creation of a standing international enforcement unit authorized by the assemblies of the states parties could reduce reliance on reluctant national authorities. Moreover, ICC could adopt a more victim-centered approach by expanding reparations and outreach programs, thus operationalizing solidarity through restorative justice. Now, talking about strengthening the United UN system, human rights system, the UN human rights framework must move from naming and shaming to more structured compliance mechanisms. Now, let us talk about the emerging areas of solidarity. And I would like to conclude by saying that uh, the pursuit of sustainable peace and justice in today's divided world cannot succeed without embedding global solidarity as a structural principle of international law. Fragmentation manifested in the rise of nationalism, selective compliance with international rulings, and widening inequality has eroded trust in existing institutions. In this paper, I have tried to show solidarity and rule of law when reimagined together provide the conceptual and normative foundation for a more resilient legal order. The analysis of existing mechanisms revealed a mixed record. The International Court of Justice has advanced um, doctrines of collective responsibility but remains limited by the consent based jurisdiction and weak enforcement. The International Criminal Code, which embodies the aspirations of accountability, yet its reach is undermined by great power resistance and structural dependence on state cooperation. Similarly, the UN human rights machinery has achieved universality of coverage through mechanisms like universal periodic review, but remains constrained by political polarization and lack of binding authority. The reform is therefore needed. The paper has argued that solidarity must be reconceptualized as a binding legal principle codified al- alongside fundamental norms such as sovereign equality and the provision of force. Thus the strengthening the International Court of Justice and International Criminal Court through compulsory jurisdiction, standing enforcement mechanism, and greater victim-centered approaches would enhance credibility and accountability. Similarly, revitalizing the human rights systems by granting treaty bodies uh, greater authority, curbing politics in the Human Rights Council, and foregrounding collective rights would align global governance with the shared challenges of our era. With this, I would like to conclude my presentation here. Thank you.
Thank you, Pallavi.